And finally, another puzzle, what about the institution's social functions? Can we suppose that the American death penalty is undertaken as an instrument of crime control and social ordering? Is it a means of reducing crime, upholding law, keeping Americans orderly? This seems unlikely. Even if one were to accept, for the sake of argument, that penal institutions play a substantial role in the reproduction of order, and I'm not sure that they do, it's hard to believe that a penalty that affects so very few people could have a major structural impact of this kind. It's easy to see that 2+ million people in prison and jail, 10 million of them moving through the carceral system every year, has an impact. It's harder to imagine that 120 death sentences or 53 executions made a major impact on patterns of crime out there. Even the function of retributive justice, even the idea that the death penalty is just about punishment, seems to be badly served by a system that takes so very long to deliver the punishment, and in fact in 2/3 of cases doesn't get around to doing it at all, and which often in the process turns the condemned, convicted murderer into a kind of object of sympathy, which he or she, usually he, becomes by the time the execution rolls round, at least for many people. So what I want to do in this book and also in this talk is to proceed by looking more closely at the specific characteristics, the institutional forms of the modern system, asking how these peculiar forms came into existence, and another time, not today, how exactly they function. I'm going to describe 7 specific characteristics and say a little about each of them. Let's begin with the law, the jurisprudence of death, what Justice Clarence Thomas has described as a Byzantine jurisprudence. I would describe this as the procedural maze. This is the first characteristic I'm going to discuss, the procedural maze. The capital punishment process is now overlaid by a set of rules and procedures that is more complex and more elaborate than any other in the American legal order. In other words, there's more procedural complexity regarding capital punishment than any other civil or criminal process you care to mention, and much more complex than any other legal order which still maintains the death penalty or used to. In other words, it's a very distinctively American process. Now, this dense maze of procedural requirements ensures that any particular case will be constantly delayed and deferred, so that an average of 12 years will pass between a sentence and an execution, if it occurs at all. There's a Texas case awaiting execution this year where the death row inmate had served 31 years up until now, and he may or may not be executed by the end of the year. This same complex of laws and procedures, this same labyrinth of procedure, ensures that in the end, fully two-thirds of death penalty sentences will be reversed prior to execution. That's not to say that the people will be found innocent. It's to say that the death sentences imposed upon convicted murderers will be reversed and replaced by other sentences, characteristic of life without parole. So as a consequence of all this procedure and all this complexity and all of the adversarial legalism it involves, completed death sentences, that's to say executions, have become very rare indeed. 50 or 60 per year in a nation where 12,000 homicides occur that are capital eligible each year. So of 12,000 capital arrests, potentially at least, 120 result in sentences, less than half of that result in executions. Second specific feature, varieties of capital punishment. What we are pleased to call capital punishment, as if it was all one thing, actually exists in a variety of ontological forms, as a law on the books, as a sentencing practice, or as a practice of judicial execution. States like New Hampshire, for example, have the law on the books, but they do not impose death sentences. States like New Jersey impose sentences, but haven't carried out an execution since the 1960s. States like California impose many death sentences, but execute very few of them, which is why they have 650 people on death row. And then, of course, states like Texas or Oklahoma or Virginia have the law impose the sentences and carry out frequent executions. In addition to which, there are 12 states that formally do not have the death penalty. And I should add that right now, about a further 11 or 12 which have moratoria, where they have stayed all executions pending constitutional challenges to the lethal injection or other problems of process and procedure. So, varieties of capital punishment. It's not all one thing. We're not talking about the same thing in Texas as we are in New York. Thirdly, relatedly, geographies of capital punishment. The ontology of capital punishment I just described maps onto a very specific geography. Abolitionist states are concentrated in the northern tier of the country, mixed states are in the middle tier, and execution states are heavily concentrated in the south. Think about Kentucky. It's had 2 executions since 1976. It's got 39 people on death row. It's a mixed state. It has the capital punishment law. It imposes sentences, but it executes very few of them. And it's in the middle tier geographically of the country. That kind of fits. The next feature, the next phenomenon I want to mention, the fourth, is jury sentencing. Something which has come to seem natural and obvious to many Americans, but which, believe me, is very peculiar, very distinctive. The decision to impose death, which is quite separate from the decision to convict of capital murder, is made in this country not by a judge, not even by the application of a legal rule, but by a jury of lay people who are given discretion to decide thumbs up or thumbs down on the basis of their discretionary judgment. This, of course, means that the composition of the jury, who's actually there, the prejudices of the jury, their understanding of how the world works, who's to be believed, who's not, who's dangerous, who's not, and, of course, also the narrative skills of the prosecution and the defense become crucial determinants of the outcome. No other country allows jury sentencing, and in fact, in the American criminal system, only 5 states allow non-capital jury sentencing. This is a very unusual arrangement introduced specifically for capital punishment, distinctively American. Fifth characteristic, victim involvement in the penalty phase. Since 1991 and the Supreme Court's decision in the Payne versus Tennessee case, the victim's relatives have been entitled to present what are called victim impact statements to the jury as part of the penalty phase discussion, when basically the jury is deciding should this person live or die. Now, these statements, which of course are typically very emotive accounts of private grief and suffering, they have the effect of personalizing the harm that's been inflicted by the offender. And therefore, they seem to kind of reintroduce into criminal justice what you might describe as the logic of the private feud, rather than the neutral process of public justice. Once again, distinctively American. All the capital punishment systems that existed in the West, none of them ever used this method, at least not since medieval times. Sixth item, penultimate item, racial disparities. This is not distinctively American, I should say. In the American legal system today, laws are facially race neutral, and race discrimination is strictly prohibited. It's nevertheless the case that racial disparities are routinely produced by the death penalty process. Research consistently shows, everyone knows this, that race, social class, and the quality of legal counsel are the chief factors that structure outcomes, with the result that poorly represented blacks convicted of atrocious crimes against white victims are the group most likely to be executed.